With the last-minute agreement on Brexit, the EU and the UK were able to prevent an impending data chaos. A 6-month transition period for free data exchange was agreed in the exit agreement. A solution is now emerging in which the UK will be permanently classified as a safe third country through an adequacy decision, permanent only until they diverge. In December of last year, the negotiators were able to negotiate a regulated Brexit almost at the last minute, which, in addition to other serious consequences, prevented data chaos. Because with an unregulated exit, Great Britain would have become a so-called third country overnight, which they did, but in that case, personal data of EU citizens would then no longer have been allowed to be transferred to the island as easily as before. And given the high level of networking between the continent and the UK, the consequences would have been very considerable. A transition period of several months was therefore agreed in the agreement, during which data traffic can continue to flow as before, and the UK is explicitly not classified as an insecure third country in that regard. For now. Initially, this regulation will apply until the end of April, but an extension until the end of June is possible, which will almost certainly be exhausted. The data exchange therefore only has to be placed on a new legal basis for the time thereafter. The interim solution was particularly welcomed by the local and British data protection authorities, especially in the business world, and they particularly praised the avoidance of the otherwise inevitable legal uncertainties. Some lawyers objected that such a special regulation with a third party, as Great Britain now is after the exit from the EU, was not allowed at all, but it was objected that the agreement was an international treaty that took precedence under EU law. A follow-up solution must therefore be found for the period from July. Otherwise, the same situation threatens as 6 months before that. That means Great Britain will then become an insecure third country, and the previous practice of transferring personal data is no longer permissible. This problem can be dealt with by the EU agreeing on a so-called adequacy decision with Great Britain. With this, the EU declares to a third country that a similarly high level of data protection is guaranteed there as in the EU member states, and thus personal data can also be transferred without restriction. Countries such as Switzerland, Japan, New Zealand, and Israel are currently classified as such safe third countries. Without such an adequacy decision, the transfer of personal data is not impossible, but it becomes much more complicated. The provisions of the GDPR apply here, which, for example, provide for the conclusion of so-called standard contractual clauses or enable data transfer after the explicit consent of the parties concerned. In practice, however, these solutions are usually associated with considerable effort. The back and forth about the regulations used to exchange data with the USA, just saying safe harbor and privacy shield, also shows the uncertainty with which such regulations can be fraught. In the meantime, the EU Commission has signaled that after examining the data protection provisions there, it would also like to issue an adequacy decision for the UK and thus attest the country a level of data protection comparable to that of the EU. A press release announced that a procedure to adopt this decision was being initiated. The prerequisite for the adoption of the decision is, however, the approval of the EU member states. Beforehand, the European Data Protection Committee, the EDPS, must also issue an opinion on this plan. If the adequacy decision is implemented, it will initially run for 4 years. During this time, the EU Commission wants to use established procedures to check whether the level of data protection in the UK continues to be at the required level. Should there be developments that reduce data protection, the Commission reserves the right to restrict the decision or even to repeal it completely. The EU Commission justifies its positive judgment on the level of data protection in the UK, among other things, with the fact that the legal norms on data protection there were still based on the European Data protection rules, in particular the GDPR, and therefore contain largely similar regulations as within the EU. In addition, the United Kingdom has undertaken to remain a party to both the European Convention for the Protection of Human Rights and the Convention 108 of the Council of Europe, the only binding multilateral data protection instrument. In the opinion of the EU Commission, the UK remains a member of the European data protection family despite leaving the EU. However, critics point to the dubious role that British intelligence services have with regard to uncontrolled access to personal data. For example, the GCHQ, the Government Communications Headquarters, in particular hit the headlines in the course of the Snowden revelations, when extensive data collections of this service gradually became known, which did not only affect British citizens. The cooperation of the British Secret Services with those from other countries, and there especially the USA, within the framework of the so-called Five Eyes alliance, should also raise fundamental questions about the protection of personal data. And so I will not be surprised if I see that going to court. And we will talk about this topic a little bit more in the next weeks and months, I'm quite sure. And if you want to stay informed, please subscribe to my channel. Auf Wiedersehen.